Okay. Welcome to an episode of the Roundup. I am joined here by lawyer Ann Benaroya and Jason Blair, who I've been has had been on my show several times. And we were talking about this week. We have some big news or some big things coming in the Adnan Syed case. This week he is going to face a JRA hearing, or at least start it. We'll kind of talk about it, what we think is going to happen this week. But we also wanted to just talk about the JRA in general. And also, there is a Supreme Court case in front of the Maryland Supreme Court this week that may have a bearing on Adnan Syed. So I kind of wanted to start with that. Um, so I guess go ahead and get started. Let's start with the case that's coming before the Supreme Court of Maryland this week. And that is a JRA case. I can't remember who the person.
Montague. Montague versus State.
Montague versus State. And his argument is that they are arguing is whether if someone that doesn't or say that they're guilty of the crime that they went to jail with, can that be held as the sole reason for them not to get relief under the JRA? Or I am misunderstanding it. So, Ann, go ahead.
Well, because and this goes to the difference between adult sentencing and juvenile, the difference between the Juvenile Justice Act and adult criminal law. Rehabilitation is the goal of the Juvenile Justice Act. It's hard. I mean, it's baked into the Juvenile Justice Act when every state adopted a Juvenile Justice Act. Juvenile justice, the goals are not punishment. Punishment in adult sentencing, the goals of sentencing are punishment. That's rehabilitation takes kind of a backseat. Specific deterrence, stopping that person from reoffending. General deterrence, sending a message to the community. Punishment and rehabilitation. Those are the four goals of, legally speaking, of adult sentencing. Now, restoring the victim, that's a brand new victims' rights, restitution. Those are all new statutory developments. They didn't exist in common law. The four purposes of sentencing I mentioned are from the common law, and they've been codified in a lot of statutes in a lot of states. Juveniles are completely different because the purpose of the Juvenile Justice Act is rehabilitation. It's not sentencing. Specific deterrence and general deterrence, specific deterrence to stop that person from reoffending could arguably be encompassed in rehabilitation, both rehabilitation being the umbrella goal and specific and general deterrence being sort of falling in that, underneath that umbrella. But punishment is not the goal, not a goal or a legitimate goal in juvenile justice. Now, as the history of the Juvenile Justice Act, we could go spend hours with that. But as it evolved over the years, the states enacted statutes that allowed juveniles to be tried as adults for certain types of offenses. Juvenile meaning anyone under the age of 18, and the certain types of offenses, homicide offenses, murder, like in Maryland, for example, in the Adnan Syed case, Adnan was charged with first-degree murder as an adult. And this varies greatly from state to state, how the age and which offenses can be charged as adult, and what can be what's called reversed waived back to juvenile court. And why it matters to going back to juvenile court is the sentencing goals and the process are very different in juvenile court. But anyway, in Maryland, first-degree murder, if a juvenile is 16 or older, 14 or older, they can be charged as an adult in adult court. And if the juvenile is 16 or over, they cannot, I believe it's 16 or over, they cannot transfer the case back to the juvenile court, even as long as first-degree murder is a charge in the indictment Second-degree murder can be what's called reverse waived or transferred back to juvenile court. And why it matters is that gets us to the point of this juvenile justice restoration, juvenile restoration. The sentencing goals are completely different than adult sentencing goals, or at least significantly different for purposes of rehabilitation. And that's why when you said, what would be a legitimate basis for modifying modifying an adult sentence might not necessarily be a legitimate basis for modifying a juvenile sentence. Admitting guilt, you see, in the juvenile process, the juvenile is adjudicated as being delinquent or not delinquent. The finding is not guilt or innocence. So it's a different system. And so the sentencing is different. That's what I wanted to point out when you were saying, to be a little more precise about what the issue is here.
Okay.
And that's why, because a juvenile is adjudicated as delinquent or not delinquent rather than guilty or innocent, the question is whether the juvenile, a minor who's tried as an adult, needs to admit that he was quote unquote guilty of the offense in order to show rehabilitation. That's the issue.
Okay.
So,
go ahead, Jayson.
I was going to say, so, and is that another sort of blurring line issue between, the way we treat juveniles when we charge them as adults? What are we really, really saying, and what are we really, really doing, in the sense that, are we holding them responsible for delinquency? Because when someone's sentenced as adult, my understanding is you are getting those 4 common law purposes.
That is correct.
Stays the same.
Yes.
And so it's trying to figure out where we, as modern America, modern Maryland in this case, are going to draw the line between those
exactly, because a juvenile who's been tried and sentenced as an adult, the question here is really whether that juvenile gets the benefit of the Juvenile Justice Act if in sentence modification under the Juvenile Restoration Act.
Yeah, because Maryland Juvenile Restoration Act, the Supreme Court rulings on juveniles and life sentences and death sentences all suggest that at least the courts and also the legislatures believe that even when you're trying a juvenile as an adult, they still sit in a different place than your regular adult.
Correct.
Yeah. So where those lines are.
Well, because again, all states have sentencing guidelines, the feds and the states have sentencing guidelines, and the defendant's age, like even with adult sentencing guidelines, the fact that a person is a juvenile will show up in the guidelines. But
Okay,
not the same way, but the guidelines for juvenile versus adult, there was like just a seismic shift between juvenile court and adult court.
Okay. So maybe I'm being naive, because I was thinking that the bigger reason that they wanted to do this was that the understanding that there's many times when you're younger, you're put in bad situations that, like the Centoya Brown kind of case, where like you're poor, you're members of the gang, you're not fully mentally aware. So when you're under 18, you could be in an abusive home. So that these are all the excuses that the general or the people in Maryland were trying to say, that, hey, as an adult, if you've learned what those mistakes were, that, hey, I realized I was wrong to be in a gang, or that I shouldn't have followed orders, I've grown out of it, then you should be able to have a chance of being able to get out. I guess I'm wrong in that understanding, or is that part of it too?
No, it's not wrong. It's just too generalized, because the issue, what you're talking about is growth and maturation, but the issue is whether the defendant must admit guilt in order to, whether admission of guilt is required to show rehabilitation. Okay. For example, we have like the model that's been suggested in the briefs, and that's in DC case, is with professional licenses, like when doctors, lawyers, accountants, people who have a professional license. Instead, it's it's this person's livelihood, so they lose their license, they've lost their livelihood, and they can't support their family. They say a lawyer is, for example, has a drink, gets a DWI. That lawyer would report himself to bar counsel. All lawyer licenses are overseen by the Maryland Supreme Court or each state Supreme Court. Anyway, point is, the lawyer would need to show that he's rehabilitated himself, his drinking problem. Obviously, or he wouldn't have gotten a DWI. And so he shows that he's rehabilitated himself and gets his license back, or gets his license back. So sort of the model for rehabilitation are offenses that growth rat maturation, where a series of events where the defendant, the accused, can over time demonstrate by conduct that whatever the problem that caused the crime it no longer exists, or that it's being addressed.
Yeah, and I get the logic argument, right? How do you rehabilitate from something that you don't admit you do? How do you admit to something to prove you? Yeah, right. And would you admit to something you didn't do to prove you rehabilitated? Well, that would be the same. So they're kind of stuck, if that makes sense.
Well, but I guess the question is, I don't know the Montague's background, but if you were able to say, hey, yes, I mean, I wasn't the one that killed this guy, but I was in the gang, and I understand what was wrong with being in a gang. I mean, and I didn't have a choice. I've gotten my degree where I can maybe go into plumbing or something that shows like you have a life skill. I would think that, I mean, I think you could show that without ever any guilt. I guess that's what's going to come up on this.
Well, remember that
case.
These folks they've been incarcerated in the Division of Corrections. They've been in prison. So it's not as if again, the adult sentencing goal of rehabilitation, it's basically lip service. It's not. Most states, in Maryland, we're better than most, have very few programs for genuine rehabilitation. The problem that so many folks face when they're paroled out into the world is they're unemployable because they have a felony conviction, so they can't get public services. They're excluded from all kinds of employment involving money. You see my point?
Yeah, so, I guess we're skipping ahead to the end. I mean, didn't Adnan at least take some higher educational credits as in part of in the his last year?
Sure. I mean, I don't know. I'm okay. DOC's offerings for quote unquote rehabilitation. You know, how to say this? Can a person learn a trade in prison?
Right, well, vocational courses, right.
It really depends on the prison and how that person is classified to begin with. You see, that gets to my point about Mr. Syed having a stacked sentence that I think was illegal. He was classified in a higher security prison where there were fewer opportunities for rehabilitation than there would have been had he gone to the Eastern Correctional Institute, or one of the lower security prisons. So much of this showing rehabilitation depends on the nature of the offense, because the nature, and not just on paper, when the judge, when the convicted person is asking the judge to reconsider the sentence or to modify the sentence, but way back when the person was originally convicted and how DOC classified them, because a person with a conviction for first-degree murder and kidnapping is going to get classified in a much higher security facility than someone who has who's convicted of money laundering. So, and there will be more opportunities available in a lower security facility. And of course, how much time a person is serving also depends on how they're classified within DOC. So we have how the judge, we have the legislature making certain mandatory minimums like 15 years. Adnan had to serve 15 years. Life is not a determinate sentence. He was sentenced to life with parole, and kidnapping 30 years stacked, 30 years consecutive. Now, I think they should have been served concurrently. All his other offenses were served concurrently. But my point is this: when DOC went to classify him, let me rephrase that. When he was sentenced, he had to serve 15 years of the determinate sentence, which is kidnapping 30 years. He had to serve 15 years of that before he could even start to serve the life sentence. In other words, he didn't start serving his life sentence until 2014.
Okay, let's go real back to the case this week.
Opportunities for rehabilitation. Do you see my
Yes.
within
Yep,
the
okay.
system?
Okay, let's go real quick back, and then we'll go to move to Adnan. So the oral arguments are Tuesday morning. Is that correct? Or does it?
I'm not sure.
Okay, this week. I can't remember. Okay, so do we? I guess this would be the area of speculation. We don't know which way. Like, do we think that it's going to be close though? We think maybe it's going to be like a 4-3 decision, or we're just speculating.
It's hard to tell. I think because the issue. I mean, I think the court is going to give a very thoughtful opinion. It's going to be completely up to the trial judge. I don't think that we can have a caveat, a per se rule that I think it would probably violate, especially because we're dealing with juveniles, violate their right to the process, their due process, and maybe even the Eighth Amendment, cruel and unusual punishment. If the Court of Appeals were to say per se, if you don't admit guilt, then you cannot you can't modify your sentence. I think that's a real problem because in a lot of cases, and I think Montague might be one of them, we have multiple convictions where, like you said about the gang, like I'm convicted of second-degree murder or not, pardon me, first-degree murder by felony murder. So am I going to admit intent to kill? No, I had no intent to kill. I intended to rob the bank, but I didn't intend to kill anyone. So we have those types of issues because of the way the law works, right? And I think felony murder presents a really big problem. And I think that might be an issue in the Montague case for intent, because Montague, I'm not sure that it is a felony murder case, but let's assume for the sake of argument it is. In a felony murder, I don't intend to kill when I go into the bank to rob it. But if let's say that my friend and I go into the bank to rob the bank, we intend to rob the bank, and the teller kills my friend. I'm guilty of murder by transferred, or felony murder is transferred intent to kill. I didn't intend to kill anybody, but I put myself and my friend and I put ourselves in the zone of risk for that where death is foreseeable, right? We're bank robbery. So, and we're armed robbery, we're using guns. So let's say, my friend dies, and I'm charged with felony murder, and I didn't intend to kill. So that's my friend. I didn't intend to kill him. I didn't rob a bank with him. So am I going to admit that I intended to kill him? Hell no. But I will admit that he died and that my actions definitely caused it, but I didn't intend to kill him. So I think that felony murder, and I think that's an issue in the Montague case. Present any transferred intent issue. Do you see my point about?
Yes, I do.
Oh, yeah.
Really when we're talking about admitting guilt.
And do you see it being a narrow ruling, that is a safer way, narrowly ruling on this case?
Very much. I totally agree, Jayson. I'm tied to the facts because, again, that's how criminal law is entirely fact-driven, more so than just about any. I mean, all areas of the law are, but this particularly. But I think the court will say we can't say we cannot make a blanket rule that the proponent of a JRA motion to modify the juvenile, in other words, must admit guilt or must not. I don't think that the court can make that ruling without a per se ruling. I don't think the legislature could enact such a statute without violating the rights, the juvenile's rights, or the proponent of the motion to modify, without violating that person's rights to the process he or she is due. Because
and the plain language of the JRA certainly suggests that the legislature didn't intend for that.
I totally think that, and this is the reason why, is because the whole purpose of the Juvenile Restoration Act is to, I think the Watkins case that recognizes that juveniles, sentencing them as adults raises a lot of problems. And then when we look at the substantive law that we're dealing with, like again, felony murder, any transfer intent, or any inchoate crime, conspiracy crimes like that, we have a lot of issues about admitting, quote unquote, admitting guilt.
And it's interesting to me in Maryland's Juvenile Restoration Act, the way that they've broken out rehabilitation separately from things like vocational courses and
Absolutely.
educational programs. They've broken it out from maturity and fitness to re-enter society. So they're looking at it as like one tiny piece of a much bigger picture that we may all associate with rehabilitation. Like we may personally associate it with rehabilitation, but I think what rehabilitation is in our criminal justice system is so fuzzy because we don't spend much time on it.
Exactly, and that's why I noted that the statute requires the judge to really parse each element of it, and then the judge is free to add whatever he or she sees.
Oh yeah, any element they want.
Yeah, exactly. It's
Whether or not the Ravens won the previous day. No, just kidding.
I like that one.
And I think that's the whole idea is because of this, like you said, the interface between adult justice and juvenile justice when we're talking about sentencing is a really big deal. I mean, the purposes are different, and the way the law operates. I keep coming back to felony murder. It's very. We could see some portion, and particularly folks who come from underserved communities, and people who are, I worked for the public defender for almost a decade, felony trials, and so I know, like, it's just heartbreaking to see, how many people are sitting in prison that shouldn't be. And this was something I wondered about too with the JRA. Expert testimony on parsing the rehabilitation, because I think that's really going to be, and that's an expense that OPD public defender we couldn't afford. Most underserved folks can't afford the to have.
Well, and also you get there's some clarity because compared to a lot of pieces of legislation, the Maryland Juvenile Justice or Rehabilitation Act really parses it for you.
I think.
Yes, they do have any other factor you may include, but they've got 10 different things, and within those 10 things, I think I counted like 23 total.
I think you're right, because I know when you go and look at who testified and look at how much came from public defender and from the community. Where we can't afford to have an expert witness or a shrink come in and testify. So the legislature provided a lot of guidance, I think. And I think the Court of Appeals the Maryland Supreme Court, we used to call it Court of Appeals, it will embellish. I think they'll add what's called judicial gloss to the elements we're talking about, because there are so many of them. And Montague's a good case for it too, because it's a typical case in the sense he comes from an underserved community. He has multiple offenses, so he has a stacked sentence. I mean, it's a good case. Whereas the Adnan Syed case just has terrible facts. It doesn't present any. It's not the right case, but Montague is.
Okay, so speaking of Adnan, so let's go over that now and switch topics for a little bit and what we're kind of expecting, because as I understand it, on Wednesday he's supposed to be back in court for the talk about the JRA. I guess I'm very curious if we know like how much is going to be actually discussed Wednesday, or if this is a preliminary, or is this going to be where Souter gets up there and says, "Hey, here are the 10 reasons why that I think Adnan's sentence should be modified," and then the state would say yes, and then that would Sanford and Lee have a chance to say, "Here's why Adnan should not be released early."
I imagine that they'll have a lot of witnesses. I mean, ordinarily in a sentencing hearing, we have a ton of witnesses, like whoever Adnan was working with at Georgetown, his employers, community members. I would imagine they'll have a lot of witnesses to get to the points that Jayson was mentioning in the statute.
Yeah. And I think, I honestly think, just thinking about it, putting on my reporter hat, this is, a great way for Ivan Bates to get out of this terrible spot.
He's in a terrible position because
and nobody else wants it, right? Like if there's a way for him to hand it off, everybody would dive under the table.
I think he's
the AG.
And the problem is that, the way that it's not even the vacater case. A vacater motion is usually we're getting rid of first-degree murder because it's really second-degree, or there's an element is missing, and then we just plead out, and that's the end of it. But
it's an excellent get out of jail card for him. There are a lot of things that, at least in my reading of it, are going in Adnan's direction, because, the two main elements, one is, danger to society, and the other one is the interest of justice, and will those be served, and all the other.
You mean the vacater?
No, for juvenile.
Right. Because I think the vacater is. I think
the vacater
dismiss it. I don't think that Ivan Bates can go forward with it.
Right. Hasn't gone forward with it yet, but it gets him out of the political situation. But
totally agree.
Yeah, right. There are a lot of things going for Adnan. I mean, in terms of being a danger to society, he spent 2 years out of jail, no crimes. He, there's some obvious things going against him, like the victim's position, the seriousness of the crime that he committed, his culpability in it. But there really are, I think, more things. I mean, if you're just to count them as an unweighted list, headed in his direction.
I agree. I can't imagine. I think that, like I said, I think he has an illegal sentence. I think it should have second-degree murder. I think it should have been. But point being, I may be misunderstanding. I don't know. Maybe Mr. Bates offered life with parole, time served, we're done, and that's that, which would make total sense to me. And I think the judge would very, I mean, there's no purpose in keeping Mr. Syed incarcerated any longer. I don't, except punitive. And there's a reason he's been punished enough. I think that I agree with you. I think the judge is very likely, time served, but he will be on parole. I don't think that I can't imagine that the judge or Mr. Bates would go with would agree to no oversight because of the victim's position and the nature of the crime.
Yeah. But, I mean, I guess so. Because Sanford and Lee are going to come in and say, hey, they've hurt us again. He continues to deny it. I mean, it's still a very sore subject, and he's going on these. He put that ridiculous press conference out. So, I mean, it's more. I guess, as you said, it's more punitive. Really put him back.
And it's true. I mean, there are plenty of bad things I think you can do in the justice system, like taxing its resources or sitting around filing frivolous lawsuits against your Department of Corrections. Yeah. Not that Adnan did that. There are plenty of really, really, really unproductive things that you can do that, when you look at the Juvenile Restoration Act or a lot of sentencing issues, just are not going to get factored into it. I mean, it's neutral on his age, right? And that's a relevant factor.
Well, it goes pretty. I mean, he was 17, almost 18. So he was right on the cusp of adulthood. He couldn't reverse wave to.
Correct.
Montague was 16, so he was younger.
Right. And the nature of the offense works against Adnan. But has he complied with the rules of the institution? I certainly have not heard of instances where he was, violating the rules. He participated in educational programs. Some people, like, we could debate the whole maturity thing, but he's holding down a job, fitness to re-enter society. A lot of those things are pointing in his direction. Now, the victims are going to oppose it. The seriousness of the crime is going to be an issue. But if you look at that first 6 months after it was passed, I think out of the 33 cases that were filed, 27 were, I believe it was 27 were granted, and 23 immediately walked out of jail. And to me, just all the weight of the law suggests, and I'm no Adnan is innocent kind of guy. I think I believe he was guilty. What Jay Wilde said makes complete sense. All the evidence points in that direction, and it's not to from my perspective, it's not a matter of giving, a judgment on the law or him, but just when you look at the law and you look at the facts that we appear to have in front of us, and we'll see in the hearing, it seems like he's a good candidate for it.
Well, I think whether he is or not, he's a 40-year-old man now. He's an adult.
Yeah.
And, he has a strong community from everything that he said. He has good community support. He has family. And he has a job. He has oversight. So at the end of the day, again, we're talking about a 40-year-old man here.
Mhm.
He's not a kid. So the question is he a functional adult? I think the answer is probably going to be yes. And that gives us, life with parole and gives parole and probation oversight, which diminishes over time.
Mhm.
I think one of the issues for victims that probably needs to be addressed in all of this is if a vacuum motion is granted or a significant sentence reduction, can the victim's right to restitution, because there's a statute of limitations on that, does the victim's right to restitution
Kick in or extend?
it can and it's not going to be statute of limitations. It should be some sort of a equity issue, latches, or whether the victim can seek some sort of restitution, and whether restitution is limited to the restitution specified in the restitution statute, or whether the victim can ask the defendant, stop you've exercised your First Amendment right enough, or something like that. I mean, that would be unconstitutional, but something that would, or if you're going to continue publicizing your innocence, then you're going to have to pay me some.
Right.
That's
also a part of it. It sort of feels like between the victim's position on this, the seriousness of the crime, what other factors the judge considers, which, I think a lot of that will come from what the victims argue. Maybe they do bring in some of the post-offense behavior that has been harmful for them. Maybe they do bring that in and argue that shows that he doesn't have signs of maturity. I just think it's his to lose right now, and theirs to try and take.
Well, also the status quo. I mean, the status quo is he's on the street now, and he's through 22 years. Ordinarily, for his offense, we see like 25 or 30 years before parole. But then again, that was back in the day, and we, the taxpayers of Maryland, can't afford it and don't really want to see these long sentences. Like how much is enough?
Okay. Sorry. I wanted to switch topics. Oh, sorry, real quick. Then let's talk about restitution. I think we talked about it before we came on about the Willie Lomax Act and being able to get some restitution. I guess if he gets out with the JRA and it gets reduced, does he have means to get any restitution?
No. The Walter Lomax Act requires a wrongful incarceration, meaning an illegal sentence. Now, if I don't think that Adnan's argument is illegal sentence, I think he's just saying he's not guilty, as opposed to saying that he should not have been sentenced to he shouldn't have been sentenced consecutively. That would have been my argument, because that gives him a wrongful incarceration argument, and it does give him recovery under the Lomax Act. But how much
you would have to make that argument before this gets
right, and he didn't. I think he's waived it. So but I do think that there are some situations. I think the Lomax Act, again, all of this legislation is sort of a suite of legislation that has been percolating for about a decade, but is now passed. I think the whole goal, particularly the Lomax Act, is the people who have been wrongfully incarcerated have been excluded from the marketplace and from earning wages, paying Social Security, and so they're working at a great disadvantage. So the whole purpose of it, or I should say in part, is to make them whole, or at least to compensate some extent of their loss, because their loss is significant.
But let me throw something out to the two of you guys. It's sort of far afield from your point about restitution, but just in thinking about this broader issue of juvenile restoration, you know, there are cases where juveniles commit crimes that make you feel that they should never get out in their lifetime, and that they're gonna be some sort of exceptional situations. I think of Daniel. Do you know the Daniel LaPlante story in Massachusetts? He, yeah, so he's a teenager who broke into the homes of different families, lived in one of their houses, ended up killing a bunch of people, house to house to house to house to house, while he was juvenile. Showed some really strange behavior along the way, but nothing about, you know, there are certain crimes that even juveniles commit that really leave you wondering whether they should.
Was he mentally ill? I mean, was this
probably mental illness? Was
the NCR type of? Because a lot of these really heinous cases involve people who have serious mental
severe mental illness.
And to remember too that the standard for not criminally responsible is like Hinckley with Reagan.
Right.
It's not really
right. No,
possible to prove that
most of our mentally ill do not get the not guilty.
Exactly.
Insanity. Yeah. But I just wonder, you know, whether this is one of those things that we're going to see a sort of like pendulum swing over time, that these very good things meant to sort of restore juveniles who've been convicted of serious crimes. Something will inevitably happen. Inevitably, one of them will commit some heinous crime because, you know, just by the odds. And we'll see the pendulum swing back in the other direction if there aren't ways to, you know.
I guess that was kind of what happened with the life with parole, or back in Maryland, like 20 years ago, was the whole like at one time it was because so somebody got out killed, and they're like, okay, we're not going to let the governor let people out anymore. So that's the pendulum swinging the other direction.
And that's politics. I mean, that was Governor Glendening, and that was political. I think again, because what part of
and at the same time, that was really the beginning. I remember back then, Lieutenant Governor Kathleen Kennedy Townsend's whole focus. Do you remember those? The rehabilitation camps and groups she was trying to create. She was very focused on rehabilitation at that point. And then,
gosh, so much of the stuff is political. That's the other problem. And and look at the changes in how people consume information between 1990s and now. I don't know. I mean, politics is all about, you know, especially now politics are so polarized. So, you know, information consumption has changed dramatically. Politics are much more polarized. And I think we're much more distrustful of the government than we were back. I mean, I think we always have been, but, you know, more than then. But to your point, will there be a backlash? There always is.
Right.
Well, I guess I just hope that Adnan, whether through counseling or whatever, has figured out what his pain points or why. Hopefully, he figured out why he did it back in '99, so that he doesn't get in the same situation and that it happens again. I mean, that's our big concern is like, did he figure out? Was it? I think lack of sleep, lack of food, being young, being in love the first time. Probably, I think Hayes said something that really set him off. I just hope that he's figured out whatever that trigger was, that when like 5-10 years down the road, when he's no longer in the spotlight, that he doesn't do this again. So let's just at least, if he does get out this, in the next couple of months, that he moves on and becomes productive.
The unfortunate part about Adnan or any person who's been convicted who's arguing that they're wrongfully accused is they don't get because they're arguing they're wrongfully accused, they don't get the opportunity to show you some of the things that you want to see, right? You look at some of the other players in this story who feel some culpability or responsibility, and you can see their remorse. You can see their efforts to to change. You can see the pain and suffering that they've gone through it. You don't get the opportunity to see it when you're arguing whether you're wrongfully convicted. So I think it's hard to know. I think there are a lot of bad signs. Some of the way they've engaged with the victim's family, the press conference he had, a lot of those things. I mean, and I understand what your point about lack of sleep and other things like that, but a lot of those behaviors are once again very self-centered. And at the end of the day, the death of Heyman Lee seems to be very much about just being very self-centered. And
well, my position is that it was not a plan. There was no plan. It was a spontaneous event. And that goes to the age of the defendant.
Yeah, right. And we know people age out of.
You're right. The executive behavior. Yeah. Having said that, and again, I agree that as people as mature, being able to regard others and see oneself through the eyes of others, and as part of a community, is certainly a very important part of
helpful. Yep.
But maturity. And I think see some of the other people involved in that case have definitely grown up, so to speak. Mm-hmm. And with the problem with Adnan is it's really unclear because of like what you said, you just maintaining innocence just mm-hmm. clouds. There's no way to tell for any of the other things. I agree.
What reality is.
No idea.
Okay, I think that is probably a good spot to end, unless there's other questions or comments from
so we're clear about restitution. Restitution is a victim's every state has restitution statute, so do the feds, and it's a victim. Restitution goes to the victim, and victims are defined in the restitution statute. Whereas the Lomax Act, that's a different type of it's a restoration rather than restitution.
Right.
Just so we're clear that both. I mean, we have different. Both are victims. A person who's being wrongfully incarcerated is clearly a victim, but that person is not a victim necessarily of a crime. Whereas restitution, by definition, the victim is a victim of crime.
Okay, thanks for that clarification.
Yeah, just so
Yeah.
Okay, well, thank you for both of you hanging out with me on a Sunday evening, and this is going to be a very busy week with this case and several others, so we look forward to it. And
hopefully you'll be back for all of the cases.
I don't know. I don't have the time. I can do it maybe once a week.
Yeah, Mike. Thank you.
Yeah.
Okay. Thank you. Hang on. I'm going to end the recording.
Yep.
Take care.
Thank you for listening to an episode of The Roundup. Be safe out there, and remember, don't do anything bad that will end up on one of my episodes.